Hello, everyone. Good evening. We are very, very happy to receive you here, and we would like to thank Professor KLARE and Dr. Stanley GACEK to be here with us, and also the David Rockefeller Center for Latin American Studies, and our friends from the HKS Brazil Campus. Please feel free to get some refreshments, and let's do it in a Brazilian way, like an informal way. And just to introduce our lecturers, Stanley GACEK is a U.S. labor lawyer and a senior advisor at UFCW, one of the biggest labor unions in the U.S., representing 1.3 million workers. Stanley worked at the ILO in Brazil for 5 years, right?
Correct.
5 years?
Correct, yes.
And he has a book called Labor Relations Systems, an acclaimed book. Professor KLARE is a distinguished professor of law at Northeastern University and the current coordinator of the International Network on Transformative Employment and Labor Law.
Hi everyone, thanks for coming. My name is TALITA and I'm going to talk about Brazil and our labor reform. So we have a labor law in Brazil called Consolidation of Labor Laws, CLT, em português, Consolidação das Leis do Trabalho. And we had a labor reform in 2017, and we had subsequently changes in the labor legislations, and it occurred with a speech of a combat of unemployment and the country's economic crisis. So, and the outsourcing and on-call workers and arbitration. I'm going to talk a little bit about it. And then about on-call workers is an introduction in the labor reform, and it's a special job, and then you can understand it's continuous and in a fractional way. And this kind of job, only when there is a specific demands and calls. And the remuneration, it's only for a period effectively worked. So on-call workers in USA is different. Here we have some states and some cities, they have some laws called reporting time laws and scheduling laws or fair work laws. There's regulating this kind of on-call workers, and we don't have it in Brazil. Also, we have advance notice of work schedules, schedule change premium compensation, and minimal interval between days. To avoid clopping, it happens when a worker, like, he needs to close a fast food in the night and he needs to return in the morning, right in the morning, to open this fast food, for example. About the outsourcing, it is expressly allowed to outsource widely now in Brazil. We didn't have it before. Before the reform, and it's any kind of activities. And this kind of activities, before you have the core activities and middle activities. This difference in case law in Brazil, it's from the judicial precedent 331, item 3 for the Superior Labor Court in Brazil. And now this is overcome. And about the arbitration, I can tell you that in case law previously, the prevailing view was that arbitration was allowed only to resolve collective labor conflicts. And then now with the labor reform, is allowed arbitration in the resolution of individual employment conflicts. And it's a broad discussion in Brazil nowadays about it. And I'm going to show you a short video about the labor rights and labor court in Brazil with Bolsonaro, the president of Brazil, and the president before him, Michel Temer. The first one is Michel Temer, and the other one is going to be Bolsonaro.
Uma coisa que preocupa muito os investidores.
É o maior do mundo.
Que é o maior do mundo. Hoje eu vejo pessoas que me dizem, olha, eu tenho uma empresa lá, sei lá, nos Estados Unidos. Lá eu tenho tenho um advogado com 20 ações. Aqui eu tenho 150 advogados com milhares de ações, né? Então, acho que nós precisamos pacificar um pouco essas relações trabalhistas, que é útil para o empresário e é útil para o trabalhador.
Simplesmente.
Presidente, o ministro Paulo Guedes falou em abandonar definitivamente a legislação fascista da CLT. Pode vir aí uma nova reforma trabalhista? O que mudaria para o trabalhador?
O Paulo Guedes sabe, já tem discutido com ele, que os direitos trabalhistas estão previstos no artigo 7º da Constituição e não pode ser mexidos por emenda à Constituição porque estão nas tal das cláusulas pétreas. Ele pretende, como exemplo da última reforma que nós fizemos, facilitar a vida de quem produz no Brasil. Quando eu falei que é difícil ser patrão no Brasil, os sindicatos falam, é difícil ser empregado. E eu responderia agora, que não tive a oportunidade de responder, mais difícil ainda estar desempregado. É a situação que está o Brasil. O Brasil é o país de direitos em excesso, tá? Agora falta emprego. Porque quando você pensa em produzir alguma coisa, quando você vê a questão dos encargos trabalhistas, que atrapalha a todo mundo no Brasil, aquela pessoa desiste de empreender. Olha os Estados Unidos, por exemplo, lá não tem quase direito trabalhista nenhum. Não adianta você ter direito e não ter emprego, não ter trabalho. Então, a ideia é...
O senhor acha que a justiça do trabalho deveria acabar?
Eu acho que qual país do mundo que tem? Tá? Tem que ter justiça comum. Tem que ter Nós temos mais ações trabalhistas que o mundo todo junto. Então, algo está errado. É o excesso de proteção. É igual
o governo do senhor vai mandar um projeto de lei, alguma proposta para acabar com a justiça do trabalho, então?
Isso daí a gente poderia até fazer, está sendo estudado. Em havendo o clima, nós poderemos discutir essa proposta e mandar para frente.
Igual o governo do senhor vai mandar um projeto de lei, alguma proposta para acabar com a justiça do trabalho, então?
Isso daí a gente poderia até fazer, está sendo estudado. Em havendo o clima, nós poderemos discutir essa proposta e mandar para frente.
So I'll just explain a little bit about the Brazilian labor law system, what we call the collective labor law. And in Brazil, we have a system of sectoral bargaining. It's sector by sector, different from the US, where you have a firm by firm bargaining system. And we also have exclusive bargaining representation, but we have forced unionism. By forced unionism, I mean that there is a union, and the union represents you if you want it or not. And until 2017, we have a system of union taxes. We have union taxes. It was really a tax, because every month of March, the employees had to pay 1 day of their wages to the union. But the 2017 labor reform extinguished the union tax. And at the same time, and it was like overnight, because the 2017 labor reform, it passed very fast in the House and in the Senate. So at the same time that the unions lost their most important source of money, of revenue, they received a lot of power, because now in Brazil, with the 2017 labor reform, there is a principle called the prevalence of the negotiated over the legislated. So the unions basically can waive statutory rights, and at the same time they are in financial trouble. And in Brazil we have a strong tradition of strong employment law and weak collective bargaining, but they are trying to change it. But our unions are in trouble right now, as I said. And I'm going to show you one case, because this extinction of the union tax, it was questioned before the Brazilian Supreme Court. And the Brazilian Supreme Court quoted one case from the American Supreme Court, the Janus case. Maybe some of you are familiar with the Janus case. But the Janus case here applied only to the public sector. Maybe the Supreme Court, the American Supreme Court, will adopt the same understanding for the private sector. But this case is about the public sector. And in Brazil, we don't have collective bargaining agreements in the public sector. And so far, here in the US, 22 or 23 states still permit compulsory collection of agency fees. And so the systems are very different, and sometimes it's hard to quote a foreign precedent in a Supreme Court. And by coincidence, Janus and our case about the union tax, they were decided on the same week. Janus was decided like 2 or 3 days before. And our case was decided, I'm going to show you, it was a Friday morning, and our Justice Fuchs, I think he quoted Janus out of context. And as you are going to see, from my point of view, he just received this information from a clerk, and he says, so I will quote a precedent from the American Supreme Court, and this case was issued, and this decision was issued on the date of today. You will see. So it's a little bit funny, sorry to say that, but I'm going to show, it's a long quotation, and I'm going to show you just a small part of it. This is our Supreme Court. I would like to show it for people who are not familiar with our Supreme Court. Let me get a better picture. We have 11 justices, and the sessions are broadcasted, so people can watch live. And 11 justices, we usually say they are a soccer team, just like a soccer team. There is a Christian cross, and this is interesting. It's an interesting debate. And let me show the quotation of Janus by Justice Fuchs.
Eu trago aqui caso emblemático da Corte Suprema dos Estados Unidos. Eu trago aqui caso emblemático da Corte Suprema dos Estados Unidos, a maior democracia do mundo, e esse julgado ele é exatamente do dia de hoje. American Federation of State and Municipal Employees. Então, a Suprema Corte dos Estados Unidos decidiu que trabalhador não filiado a sindicato não pode ser obrigado, por lei, a pagar contribuição sindical denominada agency fee. A Corte estabeleceu que a extração forçada e não consentida de contribuições sindicais viola a primeira emenda da Constituição norte-americana, a qual garante as liberdades de expressão e de associação.
So it was just the beginning of the quotation. I think we already talked a lot, so let's hear a little bit from our lecturers, and I thank again Dr. GACEK and Professor KLARE to be here. So I will give the floor to Mr. GACEK.
Thank you, Dr. João. Good evening, boa noite a todos, a todas. It's a great honor to participate in this panel. I do want to thank the David Rockefeller Center for Latin American Studies, the Kennedy School Brazil Caucus, and a special word of thanks for the coordination and moderation to TALITA Gonçalves NUNES of the Harvard Law School Labor and Work-Life program, and of course, Dr. João and LEAL FERNANDES. I had the honor of meeting a few months ago with a mutual friend in contact who is actually a progressive U.S. federal judge for the district in Maryland, who actually found admissibility. One of his, it's before the circuit now, but he did find admissibility in one of the Emoluments Clause actions that were brought against the current president of the United States, and he's a Brazilian and has a great interest in Brazil. So through that, I was able to meet Dr. João. I want to say that it's an honor to share the panel with Professor KARL KLARE. I have been reading KARL KLARE for years. When I was a third-year law student at Harvard Law School, his work, the judicial de-radicalization of the Wagner Act, was very impressive to me. Very, very depressing too. Although I would argue that things maybe have even gotten worse since 1978. but I'm really, really, really honored to be with him, this panel. And again, a matter of personal privilege. I don't want to embarrass people here, but I wanted to point out a few people here who have been friends and colleagues. I'm very happy, and actually a good friend. She is the daughter of the president, former president of the Central Única dos Trabalhadores, Wagner Freitas. Is Ana Carolina Moraes Freitas is with us this evening. She's actually been studying English in the Boston area, and I'm also very, very happy that Elaine Bernard, the former executive director of the Harvard Trade Union Program and the Harvard Labor and Work-Life Program, is here, and with her husband, Greg, longtime friends, and Greg has been a member of the Teamsters Union, a militant trade union representative, and they've been people that have been very, very close to me throughout the years, so I'm very happy they're here. I assume that Professor KLARE may address some of the continuing and more recent deterioration of trade union rights in the NLRA system, including the Trump NLRB and the courts, for example, decisions such as Johnson Controls empowering employers to terminate union recognition, even the process of negotiating a new collective bargaining agreement prior to the termination of the former agreement, the new rule by the Trump board overturning the more expedited recognition elections, rule from the Obama board, and what is we see the erosion of the joint employer doctrine. I'm going to defer to him on a lot of these points. Venturing a general comparative analysis of Brazilian U.S. labor relations law within 30 minutes is mission impossible. So what I present tonight is going to be a very partial and deficient review, if even that. Brazil, its current legal political conjuncture is highly complex, to say the least. It's not just another country in Latin America, as the great Thomas Jobim once said. It's not for beginners. This is hardly a value-free presentation on my part. I have my clear biases as a trade unionist, as a trade union lawyer, and having had the privilege of following and working with the Brazilian union movement and the Novo Sindicalismo at that time since 1981. 1981 was my epiphany year, my first trip to Brazil. I was part of a small coterie of trade unionists. There were two of us who were U.S. unionists and two West German trade unionists. We were the Solidarity delegation for 11 metalworker leaders who had been tried and then convicted by the military dictatorship under the national security law simply by following the will of the membership and of the rank and file and extending a strike beyond the paltry collective interest arbitration by the labor courts known as the decidio coletivo. And the great leader, of course, of those strikes was none other than Luiz Inácio Lula da Silva, later become president of the Federative Republic of Brazil. That was my introduction to Brazil, and it was an epiphany, and I was greatly, greatly impressed by the new unionism, by the new democracy, the attempt to return to democracy. What I will be talking about tonight, towards the end of my intervention, is how the U.S. labor movement is coping with the situation, how this might be maybe of some interest and illustration and aid to our sisters and brothers in the Brazilian labor movement. Obviously, I'm making my presentation in English. I can revert to Portuguese, meu sotaque muito puxado gringo, with the Brazilians and other Lusophones who wish to talk after this panel has concluded. At the risk of sounding really sardonic, I would say that this panel could be renamed, or maybe should be renamed, the Brazilian Ongoing Labor Reforms and the American Nightmare. And what do I mean by that? There's always a great danger in destroying fair and stable labor relations in one country by applying and incorporating doctrines and practices from another country totally out of context and into a context which is historically and structurally very, very different. So what's the relevance and importance of the topic for tonight beyond the pure academic value, which I would say is not insignificant? So to put the question another way, what's the importance of Brazil to international labor, including U.S. unions, to North American students of comparative labor law? Why is this topic of relevance to the study of labor relations law in the United States? The importance of Brazil in comparison to the United States may be self-evident to everyone in this room, considering I gather the majority of people here are Brazilians. But it may be worth speaking about the obvious just for a minute. Brazil is the 5th largest nation in the world in terms of population, with over 211 million, with a total labor force of well over 100 million, and still among the 10 top economies of the world, notwithstanding the current economic stagnation and an official unemployment rate, meaning it's much more, of 12.5%. There's also historical, geographical, cultural, institutional characteristics of the two countries, which favor a comparative analysis of their labor relations systems. I'm not going to have the time to go into all of these, but let me offer a few comments. Even with very different timings of industrialization, both countries have a common 19th and 20th century history of trade union struggle, militancy, draconian state and employer repression, including great violence to crush that militancy, and then an institutional recognition, legitimation, incorporation legally, and about the same time, with the New Deal and the Wagner Act of Franklin Delano Roosevelt's administration, the Estado Novo, and the Consolidation of Labor Laws of Getúlio Vargas. This is actually true. This is not apocryphal. When Roosevelt met with Vargas and trying to convince him to make sure that Brazil would stay with the Allies in the Second World War and attempted to secure his agreement to have Army Air Force bases in northeastern Brazil, he actually said, "I want to congratulate President Vargas for installing the New Deal in Brazil." There are economic, trade, commercial, financial, migratory dimensions linking our two nations now more than ever, even though China has replaced the U.S. as Brazil's #1 trading partner. 11 years ago, the U.S. continues to be the major source of FDI, as the largest importer of Brazilian manufactured goods with value added. Consider Embraer aircraft, also Embraer aircraft being serviced and manufactured in part in the United States. And of course, the Bolsonaro-Trump summit in March of last year, they've talked about, and there's still rumblings of possibility of seeking a free trade agreement. And over the last decade, U.S. companies to continue to maintain the ranking amongst the 50 largest enterprises in Brazil. And over the last 2 decades, Brazilian multinational giants have increased their investments in operations in North America. In my union, the Food and Commercial Workers, where we represent packing house workers in North America, our largest employer is Brazilian. That's JBS Friboi. And also, there are, as many of you know here, there is a large number of Brazilians living and working in the United States, probably roughly around 1.3 million at this point. According to the U.S. State Department, there are now approximately somewhere over 200,000 U.S. residents in Brazil. And there is also an official and formal recognition between Brazil and the United States on the importance of exchange on labor relations in the labor field. That was a memorandum of understanding signed in May of 2012. It was renewed in the summit meeting in Washington, D.C. in June of 2015 between President Obama and President Dilma Rousseff. Also in that same summit at that time, a totalization agreement, what's called totalization agreement, which guarantees the portability of Social Security rights between the United States and Brazil, with U.S. workers in Brazil and Brazilian workers in the United States, and also to avoid double taxation. That was signed. In the current administration, with regard to both these instruments, I have no idea where they are. But perhaps some of the Labor Department or someone better informed here could let me know. Nevertheless, labor relations law in Brazil and the United States have represented two distinct and highly divergent models for many years, with the Brazilian case highly identified with state corporatism and the American reality being associated with the ideal type of liberal contractualism. The common law, case law tradition, obviously, still a powerful influence in U.S. law, even in the interpretation and application of administrative law systems, such as the National Labor Relations Act regime. In contrast, we have the Brazilian reality, historic civil law legacy, system of codification, far more general and universal, but which also permits many more alterations and revisions of precedents and summary doctrines, or summas, without exactly the same limitations of stare decisis in the United States, or at least we thought that prior to Janus. The theory and role of the state vis-a-vis labor relations and the guarantee of labor rights is also very different, regarding both collective bargaining and legislative worker protection and rights. At both the constitutional and the infra-constitutional levels, there is, by comparison to the United States, a plethora of protections and provisions. And also, with regard to the interest arbitration, collective bargaining dispute system of resolution, known as the decision coletivo system, within the Brazilian labor courts, there is what has been known as a poder normativo. That is to say, that the judiciary does have the ultimate, or has had the ultimate power to determine what would be the substantive outcome of the collective bargaining process. And certainly with regard to the NLRA system, the Supreme Court in 1970 in the H.K. Porter doctrine, H.K. Porter case, said that was not to be the case here. There's also a great decentralization of labor law and labor rights adjudication in the United States, in contrast to Brazil, which has this specialized system of labor courts. This was noted in the interview with Jair Bolsonaro, and notwithstanding his flourishes about abolishing it, which would be unconstitutional too, but a lot of what he's proposing is unconstitutional. But what, in terms of his attempting to reflect on the U.S. reality, he was not, maybe out of ignorance or maybe purposely, not actually talking about the great complexity we have in the United States with a federal, and maybe in comparison to Brazil, more of a confederal kind of system with state regimes in terms of minimum wages, in terms of occupational safety and health, even in terms in checking, paring down the employer's absolutely arbitrary power to sever an individual contract. That is a reality in the United States, albeit that we do not have a national federal doctrine of just cause, but that at the federal level, still at will is basically our regime. Now, based on what JOÁO mentioned, and also TALITA, for North American union leaders as well as others from throughout the world, what had been the Brazilian system prior to the recent reform of 2017, and then with the devastating measures taken by the Bolsonaro administration beginning in 2019, including the abolition of the labor ministry, by the way, and basically seconding its functions to the justice ministry and the economics ministry. Also, what is known as, it's like an executive order, although the Congress has to act on it or it'll die, as a medida provisoria was promulgated by Bolsonaro, ending dues checkoff, even for those who were actual voluntary members of a union and had authorized their dues contributions. But prior to all this, the Brazilian system might have looked like a paradise. The guaranteed trade union monopoly, or unicidade, that JOÁO has just explained, which basically says that for a sindicato, there cannot be more than one union per geographical area not inferior to a municipality for a professional category or economic activity. In other words, for the bank workers of Sao Paulo, the city of Sao Paulo, they're based on unicidade, there can only be one union. Now, there was also, and JOÁO pointed this out, with the Contribuição Sindical, also known as the trade union tax, Imposto Sindical, a guaranteed income stream, which was financing this pyramidal structure of the municipal sindicatos, federations, which are generally state, but also can be national and national confederations. But one of the great deficits of the system was a lack of in-workplace representation or organization, in great part, not in all cases, lack of empowered unions through authentic, voluntary self-organization, and continuing deficits in achieving a thoroughly developed culture and practice of collective bargaining, albeit legally recognized for many years, but very, very much had been historically overdetermined by the mediation and decisions of the labor judiciary. Now, it's important to understand the inspiration behind the Brazilian labor relations system. Getúlio Vargas's vision of 80 years ago was that provide major protections for workers' trade unions officially recognize, legitimize them, provide them with this income stream, restrict that income stream to the provision of welfare services to the members. In other words, strike financing, political action, intersectoral solidarity actions would be prohibited. And to keep those organizations and their use of state finance budgets under tight control and create the same system for employers. I think Brazil may be the only remaining country in the world which actually has unions for employers. Ultimately control the collective dispute system with a highly interventionist system of labor courts and labor justice. The idea was to preempt the use of collective economic force, namely the strike, and also prior to the 1988 Constitution, the enabling legislation after that, there were very, very onerous preconditions to convoking a strike. This is the system of 80 years ago, hardened during the military dictatorship of 1964 to the 1980s, liberalized to a substantial extent, although greatly intact, from the period of the new federal constitution of 1988 to the present. Now, the labor law reform which passed the Congress in 2017 and has been exacerbated by Bolsonaro's measures, akin to executive measures, since 2019, reverses this labor protection legacy of the corporatist system of the last 75 years, almost in the blink of an eye. Having followed Brazil for well over 30 years, I never thought that I would see that, and that going so fast, with less than 4 months of debate within the Brazilian Congress. So I'm going to go through I'm not going to recite everything that I have on my slides, but it gives you an idea of basically what has been happening, including total outsourcing, terceirização, and a separate legislation. But that was passed a few months prior to the labor law reform being approved by the Congress, which is November of 2017. These are the chief aspects of the reform, and what this reform does is that it perversely seizes some of the banners of the new year, turns upside down, inside out the collective bargaining system, not to mention leveling a fatal financial blow to unions, which is going to be the leitmotif that I want to conclude with in my comments tonight. So you've got total outsourcing, which many employers, thankfully, have not really implemented. A defender, by the way, with regard to the outsourcing, terceirização, the defender said, well, but no, it will be the union of those employees who have been directly employed. For example, the metal workers of Sao Paulo, they will represent the terceirizados for collective bargaining purposes, or those, in other words, those employees that who have been effectively contracted out or to provide the services. But what this does from a legal point of view in Brazil, it totally dismembers this system of the sindicato of employer with the sindicato of workers. Because it wouldn't be the sindicato for the employers for the metal trades of Sao Paulo. It would be the sindicato or the association of the prestadores, or the providers of services contracted by the metal employers of Sao Paulo, for example. So it has this, that can turn everything inside out. João has already referred to it. The bargaining has prevalence over the legislated, with the exception of untouchable section or Article 7 rights. But with regard to scheduling, hours, what had been the floors of the CLT, these are now subject to bargaining, and subject to bargaining imperious, meaning that there is nothing within the labor law reform which stops there being inferior negotiation down. Now, João mentioned what is the sectoral bargaining structure, and that is expressed in the convenções. These are the convenções. You would have a convenção between, let's say, the metal workers union of Sao Paulo with the sindicato for employers in the metal sector of Sao Paulo. What basically the legislation says is that what the law used to say before was that an individual accord, collective accord, with an individual employer, let's say Ford, could not be inferior to the floor set by the Convenção. Now, it can be. It can be entirely inferior. You can bargain imperious. Not only that, but with regard to those employees who are considered hipersuficientes, hyper-independent sufficient, in other words, those with a university degree and those who are making the equivalent of twice the maximum Social Security payment per month, which now, looking at the exchange rate, is probably about $3,000 a month. So that includes a lot of workers in Brazil, by the way, a lot of more skilled workers in Brazil. Their individual contract by the labor law reform has prevalence over any collective agreement whatsoever. And Bolsonaro has basically said he wants to see individual contracts having total prevalence over any collective agreement, which means you might as well not have any more collective bargaining, because legally speaking, it's basically gone. There's also, by the way, a current constitutional amendment, which has been encouraged by Bolsonaro, and it's been presented by Federal Deputy Marcelo Ramos of Amazonas, which would end exclusive representation in Unicidade. So, in spite of what has been a great structural chasm between the two labor law systems, there is now an ironic convergence, and particularly concerning the law of trade union financing over the last 2 to 3 years. The compulsory contribuição sindical, as we've noted, is eliminated by the 2017 reform. The constitutionality of that elimination was upheld by the Supreme Federal Court in 2018, actually on the same day as Janus, according to Minister Luiz Fux. Moreover, in 1998, the Brazilian Superior Labor Court already had declared invalid the practice of the assistance contributions, which would be, the practice had been that they were exacted from all workers of the relevant professional category or economic activity, only permitting them to be exacted from the associados or the members. Now, what is the difference between that and the trade union tax? It's collectively bargained. It is negotiated, and it's approved by the assembly of the workers. And that is what is different. Nevertheless, that has been legally invalidated. So you put all this together. This means that 80 to 90% of what had been the financial base for unions in Brazil is legally invalid, legally invalidated. Now, one thing I wondered, and I was accompanying this, even the move towards this when I was with the ILO in Brazil, and I wondered, where are the employers going to be in this? Because their structure, their superstructure, has a stake in this because of the unions in Brazil. And many sindicatos of employers were saying, no, we need to rely on our trade union tax. But the national confederations were brilliant. And in my judgment, they were brilliantly cynical, thinking, we in one fell swoop can wipe out a lot of the workers' unions if we get the abolition of the compulsory contribution. Because even though that's going to affect, it's going to have a lot of our sindicatos screaming about this, we can rely on, excuse my Portuguese, chupar, from the Sistema S, which is, the Sistema S is the system which is financed by payroll taxes, which provides for intermediation and apprenticeship, and which is run by the employers. What is very, very interesting is that Paulo Guedes, because he is a convinced neoliberal and a Chicago boy, he lectured the National Confederation of Industry, saying what's good for the CUT is actually going to be good for you. You can no longer be relying on this as well. So this is interesting. I only have a few minutes left, so I'm going to have to race through trade union financing in the United States. Anyway, very, very quickly, and of course Professor KLARE can elaborate on this, union security is still permitted in 22 states of the union, which do not have, right to work, or what we call right to work for less laws. And where there is union security, where it's legally recognized by Section 8A3 of the National Labor Relations Act, is that it requires that within 30 days, a new employee becomes a member of the union, or if he or she objects to that membership, and they will register an explicit objection with the union, and they would pay just the fair share fee of the cost of their collective representation. Communication workers versus Beck and other precedent that have set the groundwork for this. Nevertheless, Section 14B of Taft-Hartley Act is there, and now we have right to work laws in 28 states, which make such a practice totally illegal. And in Janus Writ in 2018, the Supreme Court invalidated agency fee clauses in collective bargaining for the entire public sector, because that Janus versus ASME applies to all state, county, and municipal employees, and already with regard to federal employees, and that's a whole other discussion about the real lack of rights which federal employees have, but they have not permitted by law to actually have union security or agency fee type arrangements. So what does international law say about all this? Let me just cut to the chase because of time. Basically, the ILO jurisprudence says that if these clauses are recognized by law and they are collectively bargained, they do not, and there's a practice to recognize them, they do not infringe freedom of association principles. So what had been recognized as the legal contribução assistencial, union security in the United States, be recognized by ILO jurisprudence, if that means anything, but I think international law should mean a little bit. That basically that is permitted. I'm not going to go into because of the time, I can't go into a long discussion on Janus, but let me just say this. Luis Fuchs's comments were totally inapposite for two basic reasons. Number one, basically he didn't qualify his remarks by noting that Janus was applying to the public sector. And therefore it was like apples and oranges. There was the First Amendment issue in Janus because of public employees. So there was that, and that was entirely distinct. The other point is that the contribução sindical was completely different from the agency fee, being invalidated, and I would argue, basically in violation of stare decisis and sensible constitutional law. But the great difference was that those clauses in the public sector in the U.S. were collectively bargained. They were not imposed by legislative fiat. So now I will just very, very quickly say that U.S. unions, and I can discuss this more during the debate period, we are coping with this, basically the situation, through constant organizing. We in the UFCW, we negotiate clauses with unionized employers in right-to-work states, which will guarantee access to new workers, but also legally speaking, a union can still do this. It will not violate its duty of fair representation. It can provide special benefits outside the realm of the collective bargaining agreement for the member, such as legal services for undocumented workers, continuing education. This is a lot what we're doing in the UFCW, and in Nevada, which is a right-to-work state, the Culinary Workers Unite here have 90% union density, many of their members being undocumented workers because they provide those kinds of services. And even with the destructive effects of Janus, public employee unions in the United States are also trying to follow what has been our practice in the private sector. California, the labor movement, managed to get state legislation giving, of course it's California, that gives the unions the right to meet with new public employees as soon as they start working. And a second law keeps private the phone numbers and email addresses of employees of public agencies in order that anti-union groups cannot have ready access to them. So even though the U.S. labor movement's coping strategies are not perfect, not complete, they're a work in progress, they may be of instructive value to the Brazilian union movement. And Brazilian unions are coming to us saying, how are you dealing with this? And we realized some seminars in Brazil with our counterparts in the food sector. So ironically, what had been the assistencialismo of the earlier union corporate system in Brazil, the medical, dental, legal services, other supports to members and their families, might now be part of the solution, ironically, in attracting more voluntary dues-paying membership. The irony, of course, is that that system was financed by the compulsory dues system, which is no more. This situation is only going to be turned around through the political action in Brazil on the part of unions, workers, and their allies in the next couple of years. along with very aggressive and innovative organizing methods in the immediate future. Ironically, our destinies as movements have never been closer. And I'm going to conclude with these words of Eugene Victor Debs, great American socialist, president of the American Socialist Party, the head of the railway workers. Also, he won 5% of the vote in the presidential elections of 1912 and over 3% in 1920, campaigning from jail. He was in jail because he resisted an unjust injunction against a strike. And he said the following about solidarity. Solidarity is not a matter of sentiment, but it's a fact, cold and as impassive as the granite foundations of a skyscraper. And to paraphrase the rest of the quote, he basically said, if identity of interest is not there, this will be mere sentimentalism. Indeed, the interest, the common interest between Brazil and the United States in terms of our union movements is now a fact, cold and impassive as the granite foundations of a skyscraper. Thanks very much for your attention. Muito obrigado. Desculpe, né, pela prolongação aqui na minha fala. Thank you.
Well, pardon me. I want to thank you very much for inviting me here. I'm very proud to be participating with this distinguished panel and among old friends. And I've had the great privilege, Joel has been sitting in my classes at Northeastern, and it's been a wonderful thing for not only for me, but for the students who learn from him as well. So I know much less about Brazil than all of you do. I have visited, but I'm not an expert on Brazilian labor law, but what I think I can do is pick up on the theme of convergence. That was a major point of the previous presentation. So in this sense, my message would be, to the extent that Brazil is adopting American-style labor relations and labor principles, you are in deep trouble, because those principles are destroying the foundations of collective bargaining and workers' rights in the United States. So you should, to the extent that your politicians tell you that the U.S. is setting a great example with our deregulated labor relations, you must study our case, not because it's important for its own right, but so that you can expose those lies. They are lies. So let me take the three things that were particularly mentioned in the 2017 reforms: outsourcing, on-call work, and arbitration. So just on on-call work, the basic idea is that you're not guaranteed any hours of work. You know, they'll say, this week we have 20 hours for you, this week we have 25 hours, maybe 30 hours if there's a lot of business, but some weeks you're going to get 10 hours. Well, that's not wonderful, but if your time, the other time was free, you could perhaps get a second job to fill in. But what the on-call employers say is that you must be available at all times during the week for us to call you in. So you must be available on 1 hour's notice or 45 minutes notice. You must call every morning at 6 a.m. and we will tell you that you must appear at noon when the store opens or whatever. And they have algorithms in their computers which say that on Thursday when it rains and it's 2 days after a baseball game or something, they will have a 3% increase in the number of customers coming into the store that day. So they'll call you in. And so you really can't, you're not able to make minimal arrangements like for childcare, let alone have another job or study in a systematic way for a degree or anything in the time that you're off. So now the issue under American law is whether that on-call time, the time that you're waiting to be called in, is it compensable or not? And it's a very long story with lots of nuances, but the basic answer of the courts has been no. When you're on call waiting to be called in, you're not on the clock. And the employer doesn't have to pay for you. So these are horribly exploited workers. Now, TALITA said that we have some reforms in the United States to address these questions, like laws about advanced scheduling of hours and so on. But I have to say, in all honesty, it is very, very rare. City of New York for fast food workers, the city of Seattle, but there is no federal legislation of this kind and no state legislation of this kind. So we are moving in the direction of permission for employers to systematize their labor flow in this way. Now think about what it's doing. What it's doing is that the employer is transferring risk from the enterprise to the worker. The enterprise has the risk that some days there'll be a lot of sales and other days there won't be. There'll be a variable flow of customers in retail and restaurants and so on. And that's a cost of doing business. They have to have the store open and ready there when the customers want to come. What they're trying to do is divest themselves of that investment risk, that cost of doing business, and putting it onto the worker by making the worker be on a string to come in on an hour's notice to do the work. It should be unlawful. I mean, in a just world, the on-call time, or much of it, would be compensable. And the cost of standing there waiting to know if you're going to be called in to do work would be a cost of the business, not a cost of the employee. Now, another example of this process of employers, what I call it, they're pushing risk downward. What they're doing systematically over the past few decades, they're finding ways to organize work, organize the flow of business, so that risks that should belong to the enterprise, costs of doing business, so to speak, are pushed onto the workers or to subordinate businesses that operate at a very thin margin. So another example of this is the problem of independent contractors. So there are some people whose work, they are, in a very real sense, independent contractors. An attorney in private practice is running a business and they have clients and, they're not employees of the client. The client comes to them for help. But there are ways in which employers can structure what is really an employment relationship. A cleaning company that hires a janitor, they can legally structure that as an independent contractor relationship. So what they will do is to say to the janitor, we want to set you up in business. Here, give us a big fee, and we will set you up in business. And you will be the John Smith cleaning company. We will then hire your cleaning company to come in. You can bid on a part of the building. It could be a Harvard building. I don't know if they do this here, but they could say that the Kennedy School, John Smith, you could bid for that, and your company will be the contractor to clean this building at night. It transfers the employment relationship into a different kind, legally different kind of relationship. What does it mean? The independent contractor has no union rights, no social security, no protection against industrial accidents, no unemployment insurance. The employer sheds all of the social responsibility that should be a cost of doing business in a modern capitalist economy. We're not in the 19th century anymore. We're in the 21st century. And the struggles of the 20th century, the struggles of generations, were to embed social responsibility into the costs of doing business to some extent, with minimum wage, with social insurance, and so on. And now employers are using this technique to find a way to shed themselves of that responsibility. Does the employee recast as an independent contractor, do they have social security? Well, they're on their own. They're not protected by the system anymore. Outsourcing is another example of pushing risk downward. The basic business in the United States doesn't make anything, it doesn't do anything. A hotel company like Hilton Hotel does not own any hotels. They don't take care of any guests. What they have is a brand. They have a brand, and they have computer software, and they have advertising specialists, and they have a name. And they franchise out to investors the Hilton property in Boston, the Hilton property in Philadelphia, the Hilton property in Chicago or in Los Angeles. That's a little group of investors. But those investors, they don't run the hotel either. They hire a management company. And then the management company hires room attendants. They hire buildings and grounds. They hire food services. They hire reservations and desk workers. So you'll be in a Hilton hotel. Everybody's wearing a Hilton uniform. They're required to follow the rules of Hilton headquarters. There are rules of how to greet guests and when to arrive at work and what the pay is going to be and so on. None of them actually work for Hilton. They work for some intermediary, maybe 2 or 3 steps down the chain. Now, why this fits with the other patterns, yes, they will have an employer. Their employer, the service company that provides the room attendants, will have Social Security responsibility, will have unemployment insurance responsibility, will in principle have to recognize a union of those room attendant workers or the gardening workers or whoever it is. But that company, the small company, operates on such a thin profit margin that if they actually pay decent wages to the worker, if they recognize a union, maybe out of the goodness of their heart they would like to pay good wages and be honest in paying minimum wage and in paying overtime and properly deposit all their social insurance contributions. If they do that, they will lose the contract with Hilton. Or they won't, because the contract will be unprofitable because what Hilton is paying them is not enough to cover the social responsibility costs of running the business. Hilton will fire them and get another gardening company or another room attendant company or another cleaning company that's willing to cheat on wages, cheat on overtime, cheat on Social Security and all of the other benefits. So the profits will flow upward. This is American life. This is the new economy of the United States. And God help us if this comes to Brazil, in whatever form or variation it will be in the Brazilian context. The basic principle of the 21st century economy is that enterprises have no responsibility for their workers, no social responsibility. The provision, the basic social contract of the 20th century, it wasn't perfect. It was never great. It always had flaws in it. But the basic idea was the enterprise bore responsibility for some minimum conditions of working people, expressed in minimum wage laws and Social Security. It was always flawed. Women were left out. They were always channeled into the secondary labor market, and it didn't get into the big time of the primary labor market where this arrangement existed. People of color were excluded. There were always problems. I'm not looking back at a glorious golden age, at the time of 1950. But for millions of people in the States, that was an entry to a middle class life, and it is disappearing. And it's not disappearing by accident or because young people have a different attitude towards life or any of this other nonsense they tell us in the newspapers. It's disappearing because capital is deconstructing it. So the outsourcing cases are the classic expression of that. One of the biggest issues in a U.S. labor law today is the question of joint employers. In the example I gave you, there is a legal doctrine that would say that the Hilton brand is a joint employer with the hotel management and the janitorial company that does the cleaning. And then the workers could then push the social responsibility back upward to the source of wealth, the source of profit. It's a very long story, but the National Labor Relations Board, the Trump administration have issued devastating regulations, devastating case decisions in the past year, which make it almost impossible to show a joint employer relationship. So the outsourcing technique is going to be a way in which the working conditions of American workers are going to be contracted. Arbitration, this is another example. When I went to law school, there was virtually no individual employment arbitration. There was only collective arbitration between unions and management. And whatever its flaws, there were great strengths in that system because the arbitration procedure was bilateral. It was part of the negotiation, part of the collective bargaining process conducted through individual grievances. And you had power on both sides of the table. Not necessarily equal power, but some real power on both sides of the table. Individual employee arbitration is different. That's a case where the employee does not have a union, they don't have a collective bargaining agreement. What they have is a statutory claim that they were fired because of their race or because of their gender, or they were paid less than the minimum wage. Now, those cases are very small in dollar amount. A person, who wasn't paid overtime might have a claim for $200. The only way to bring the claim successfully in court is through a class action, which unites 200 workers or 300 workers in the plant, and then you get to talking about money that's worth going to court to recover. So the vehicle for that is what's called in U.S. law class action. The employees come together and they file a single lawsuit. Employers have now said they can make as a condition of employment, you must sign a piece of paper that says, I will never join a class action against the employer. If I ever have a claim against the employer, I hereby surrender my right to sue the employer in a class action. I will only bring an individual claim in a Mickey Mouse arbitration procedure. And that's a condition of employment. This is outside the union sector, right? Now, the National Labor Relations Board during the Obama years took the position that employees not only have a right to join together to form a union, the phrase in the statute is mutual aid or protection. So the Obama administration took the position that when workers join together to sue the employer to defend their rights for minimum wage or racial justice, they're engaged in mutual aid or protection. They're statutorily protected, and therefore it's unlawful for the employer to insist as a condition of employment that you surrender the right to bring a class claim. So long story short, the case went to the Supreme Court 2 years ago in the Epic Systems case. It was argued by a former student of mine who was then the general counsel of the National Labor Relations Board. I'm very proud of him, but he lost in one of the worst decisions I have ever read in 40 years as a lawyer. The Supreme Court ruled that the right of employees to come together to bring a lawsuit to protect their rights is not mutual aid or protection within the meaning of the National Labor Relations Act, and therefore the employer can force employees as a condition of employment to surrender. So that's all a fancy mumbo-jumbo legal way of saying that employers have found a legal device to shed the risk of enforcement of statutory rights against them. As a practical matter now, it's extremely difficult for employees to sue their employers, even if their claim is completely meritorious. I hope I've explained it well. Now, I have to tell you, hope springs eternal. Maybe we will have a new president, but I'm very, very despairing. When I was a kid growing up in New York City in the 1950s, union density in the United States was 35%, mostly in the private sector. In New York City, where I grew up, everybody was in a union. You got on a bus, you look around, half of the people were union members. It was part of life, at least in the urban centers. Private sector union density in the United States is just above 6%. Total union density in the United States is only a little bit above 11%. So we are a non-union country for the most part. And the destructive actions of the Labor Board and the Department of Labor has fallen very hard on unions, but hardest on unorganized unorganized workers. I don't know. I'll be interested during the discussion. I don't honestly know if this can be fixed by law reform. Here's a bright note. I'll mention this at the end. Last week, the United States House of Representatives passed the PRO Act, the Protect the Right to Organize Act. It will die in the Senate under Trump, but perhaps, if there's a big change in 2020 or 2022, it might someday pass. I never dreamed the day would come when it would even be sent to Congress. But it changes many, many things. It provides for speedy union recognition without all the mumbo-jumbo that allows employers to resist unionization. It repeals Section 14B that was mentioned. In other words, it would make agency fee arrangements lawful throughout the United States, at least in the private sector. It changes the definition of independent contractor in a way that makes it impossible, not impossible, but more difficult for employers to use this trick to deprive employees of rights. It does many wonderful things. But the truth is, even if it passed, it would be 20 years, 30 years before labor could come back and claim the strength it had in my parents' generation and when I was young. So my somewhat pessimistic message, but it's also a challenge to the next generation, is can you do better than we did? Can you find more imaginative ways? It's not going to change from the law. It's going to change from the ground up, from solidarity, from creating new conceptions of solidarity, new visions of people coming together. It may not be even called a union 20 years from now. Maybe it will, maybe a new kind of union. But that's what needs to be done. In the short run, I just wish you all the goodwill and all the love in the world that you can resist in Brazil the depredations that are being described, that are happening to your labor rights. Thank you.
So we are going to open the floor for debates, Q&A. Does anyone want to make a question?
Thank the both of you for the presentation. It was both enlightening and scary at the same time. Well, you said that, quote, God help us if the same happens in Brazil, if Brazil adopts this system. And I would like to know if you could make a prediction of what we should expect, like economically, if Brazil adopts it. Because I'm not a specialist, but I think in US, at least when it happens, the money stays here. For example, we are having a lot of outsourcing from companies that are not Brazilian, like we have Uber, we have Netflix, and you said like the money is going up, and it's not going up to Brazilian companies. In the end, it's going outside Brazil. So like I think that it would be like economically worse than what is happening here, but that's like not a specialist opinion. I'm not a specialist, so I'd like to know from you what we should expect.
Yeah, I'm very, very bad at predictions. I would be a cartomanci here, but I would say that interestingly enough, with regard to the Brazilian situation, which is a nightmare in terms of looking, where Brazil was 75 years ago, and I have to say that I never imagined that this would be turned around so quickly with so little debate, and largely because the employer organizations had a stake in this system. But this was done so fast, really in the still of the night almost. You contrast that with efforts at labor law reform in Brazil, particularly during the Lula administration with the National Forum on Labor, and what came out of that was not a bad proposal, which had a real tripartite engagement, but of course, it really was trying to make the Brazilian system more faithful to freedom of association principles in terms of more representativity for unions and moving towards moving away from a trade union tax and maybe to a negotiated taxa negocial, as would be noted, or basically a proceeds coming from an organization's collective bargaining representative once it is shown a more minimum showing of representation. But a lot of what I think may be, ironically, putting some of the brakes in Brazil is just what this has done, the reform. It's created what you would say in Portuguese, and I'll try it with insegurança jurídica. You have created this basically this legal insecurity that the Brazilian employers, but maybe not foreign multinational employers, but Brazilian employers maybe recognize that they can't exploit all of this. For example, the full terceirização, the full outsourcing, I mean, that was just a complete turnabout. When, as you well know, there had been a very established judicial doctrine in Brazil, which is that the end purposes, kind of the real purposes of an enterprise, could not be contracted out. It basically changed everything. But do really responsible employers also that are looking at good productivity, sustainability of an enterprise, want to see everything contracted out with regard to production, given all the risks of poor quality? And again, it's when I was with the ILO, we were looking for more and more evidence of this. There were some studies coming out, but actually there was a certain correspondence between more contracting out and more accidents, more degradation with terms of health and safety, and other terms and conditions of employment. Since I don't know if it's an advantage, but I think a difference in Brazil is that given that there are so many individual cases which do burden the labor judiciary. But I'll just conclude by saying maybe this is too optimistic of a view, but I think that even though the legal structure in Brazil, in terms of the labor law reform, in terms of the outsourcing, creates a Frankenstein monster at this point, I'm not sure that even the employers, certainly Brazilian employers, necessarily want all the insecurity of fully implementing the system. And again, in Brazil, who knows what's going to happen? You'll have major elections in 2 years. That certainly could change a lot of this. And again, as you well know, with regard to constitutional amendments, it's a two-edged sword, but it can be constitutional amendments moving in another direction to restore more integrity. So actually to conclude, Professor KLARE mentioned the PRO Act. I mean, it is incredible. You go into it, it's even better than the Employer Free Choice Act in terms of what it's doing in terms of invalidating right to work for less. Also, eliminating a lot of secondary action provisions. Also saying that in an economic strike, strikers can no longer be permanently replaced. There are a lot of great things within this, but I agree with Professor KLARE. It probably doesn't have a snowball's chance in hell in the Senate. But the fact that it's there is important. I think it does set a very, very important framework for this, and also for this particular electoral cycle. And we in the union movement are hoping this is going to become, more and more, part of the debate. But I come out a little bit more optimistic in Brazil, only because I think there are more brakes on. Here the brakes have been off. It's completely off. And, I hope that things are going to get better, but I would also agree with Professor KLARE in terms of really getting the system changed and to move back in a more reasonable direction of what we had in the post-war period, post-World War II period. That's going to be very, very difficult.
we have any other question from the audience?
Thank you, João. Thank you, TALITA, for putting this panel together. Thank you both for the very elucidating talks. So I have actually 3 questions, 2 more direct and 1 maybe longer. The first, very direct, is how does the International Labor Organization can enforce that? Because from what the very little I know, especially from human rights, there is a lot of difficulty to enforce international public law. And second, I would like to hear more from you about the union density question. So I think I'm a political scientist, so I'm coming from what we read about parties and unions in the 50s, 60s. They were part of workers' lives. So the unions would have recreational activities, the families would be integrated, parties would be the same. I know that nowadays people are going to say that the labor relations are all different, the Uberization of economy, but this has been going on for 30 years at least. So I'd like to hear a bit more about how you think the union role has changed in workers' lives and how this might have affected union density. And finally, I would like also to hear about your American experience on how to, not sure if I'm saying the right word, but how to make help to in the formation of the law students on how to be more attuned to these topics. Because I graduated in law, and when I was studying law, I used to think that ideas matter. And as I went into political science, I see that interests matter much more than ideas. And I think that João showed us a great example today about Justice Folk's decision on how the interests matter much more than ideas. So how do you actually grow students into being more interested in those topics and more attuned to these topics? Because in Brazil, that's a big problem, as we can see in the current legal professionals in the country right now. Thank you.
I'll take the lead. Well, and the middle is union life. Well, it's. I think the picture that you give rings true, although it's not universal. I mean, there was always some unions that it was just the men, and they would go drinking beer, and the family wasn't involved, and the part of the labor movement that my parents were in, and that they grew up me as a little boy. There were the picnics, and there were the parties, and you always voted Democratic, and you always voted. You went to vote, and it was part of life. But without romanticizing the past, the key thing is that I have students now who are 20 years old, 25 years old, 30 years old. Many of them have never had a family member that was in a union. They have grown up. They have never been, I asked them, did anyone in your family ever in a union? They say, oh, my grandfather, I think he was in a union, did you ever talk to him about it? No, we never talked about it. So the experience of collective power in civil rights, in feminist movements, in labor movements, it hasn't been part of the American experience as much in recent years, and that's a frightening thing. So, we had it in the student movement in the 60s. We had the experience that collective power could produce some kind of results, and it was exhilarating. And, we did stupid things. We, made lots of mistakes. But the idea that the world could change if people come together, that was part of me growing up in the 60s. And I don't see that as much anymore. But to come to the legal education part, maybe it's just my law school. We get students who are completely excited about these things and want to find, and I think ideas do matter. I think imagination is needed, and new ideas are needed. New forms of solidarity must be created, and I think that's what legal education should be about. But I may be a minority. I'm certainly a minority voice in American legal education. But yes, interests matter, power matters, but I think ideas also matter. And the most powerful force in the world is the idea of justice. Maybe that's romantic. Can I ask a question? What does a 20-year-old or a 25-year-old person in Brazil think about unions today? Is that something that's part of life? I want to, I wait for the day when I will be in a union struggle, or is that part of unions? That's the same as the bureaucracy.
Yeah. Might be biased from my friends, but they're mostly not excited about unions. They think unions are there only to take their money, especially with the union tax. So they were very excited when that was over. So that's kind of the jam, but a upper middle class uprising. So when I got into university, my university friends are a bit different, yes.
And I will add just a comment. Unfortunately, I think that because of our union law system, we have unicidade sindical, we have forced unionism. So I think it was not good to incentive participation and to incentive solidarity. And we should really think, from my point of view, in another system to make people really participate and to make people really think collectively and to fight for their rights. And union tax was not, from my point of view, was not a good system, the trade union tax. But of course, I think that we should extinguish it slowly, just as the ILO recommends. We should give the union some time to adapt to this new reality. And it was,
I just wanted to respond to it was really insightful observation with regard to the ILO and what ILO standards and the ILO system, which are called Westphalian dilemma, which is, in many ways, it's true of a lot of international law systems, but unfortunately, with regard to labor rights and human rights, it seems to be more and more of a dilemma than with regard to capital rights, which might have systems of arbitration in order to give enforceability to their claims. But it's the problem. It's the problem of enforceability, and the ILO standards are not self-enforceable. But if international law means anything, ratification of an instrument means binding. It's binding. That is certainly the expectation of the ILO system. And conventions and protocols are ratifiable, therefore they are binding. Recommendations, declarations are not. But the fact that a country has ratified a convention and has a treaty-like aspect, and great jurist Gunther in Brazil, he wrote a great book, and he goes into detail what this means from the Brazilian perspective. It does mean it's binding. Now, the question, of course, this is something which, referring to ILO standards, because it's not self-enforceable, is a big problem. You're not going to have blue helmets being sent in because a country has ratified an instrument. But ratification should mean something, and certainly by the international law standard, international law doctrine, there is the expectation that a state member, once they have ratified, brings their entire system, the legislation, the judicial system, the executive system, in compliance with that norm. I don't want to get way in the weeds, but this is one of the interesting questions. Is there anything, even hinting of enforceability, self-enforceability in the ILO system? There is one provision in the ILO Constitution, Article 36, which actually states, There's also provisions or articles prior to 36 which talk about the ILO getting advisory opinion from the International Court of Justice and that informing the ILO in terms of various decisions. But Article 36 actually says that the governing body of the ILO could go to a conference of the ILO and recommend, and the conference could implement a tribunal to give appreciation and interpretation of the ILO Constitution and the conventions. And in the Romance languages, including with how that's translated is and with a sentence, sentencia. In English, in the English version, it is translated as award. Now, what does award mean? It means possibility of restitution. Something giving a little bit more teeth. This has never been tested in the ILO. There was a special committee a little over 10 years ago that was convoked by the governing body to explore that. They could never get to agree. But even if it's, even though we have this dilemma, ILO standards is international labor law. That is the reference, and it should mean something. I also want to get back to the point of your excellent point about union density and question of unions and what Professor KLARE said. Well, we may not call them unions in the future, but I guess I have one conviction, which I believe in, at the risk of sounding too theological in this, is that workers will always have a need for collective organization. If you have collective organization, that's what unionism is. It's basically workers banding together, seeing that they have strength in a collective organization. That is always going to be there. You see that with so-called independent contractors. You see that with Uber drivers, with Lyft drivers. It's going on. And that is going on. That actually gives me a certain hope in the U.S. and in other countries. And another point that I want to make, actually, there's been Pew research done throughout the years. Robert Reich actually did some projections on this and has written articles about this, that basically you poll workers. Robert Reich concluded that at least probably 60% of U.S. workers would unionize if they could. If they could. What does that mean? It means, again, the enabling environment is not there legally. And as Professor KLARE wrote years ago, basically the whole Wagner Act was de-radicalized. It was it's been distorted throughout the years in terms of its judicial distortion and application. So I hope I still cling to some hope. And in the digression that I made about union financing and so forth, again, we are. Yes, in relative terms, we are at the lowest point that we have been since the Second World War in terms of union density. But there's another way of looking at it. That's in terms of relative power. But look at the absolute numbers of actually union members in the United States, because we're a big country. But you're talking 14 to 15 million individuals, workers together. In absolute terms, that is a force. In terms of civil society, that still is a force. And even though union density is a crisis worldwide, it's still, when you look at absolute numbers, there still is force, there still is mobilization capacity. That's why the Democratic Party will rely on us again in the next few months.
I would just like to make a last question and to ask you, as Americans, and I can say that in Brazil, especially the business community in Brazil, they love to quote aspects of American labor and employment law. And sometimes they don't know very well how things work here. They know much about. Yeah. But they love quoting. And for example, I'm showing you, this is a famous businessman, sorry because it's in Portuguese, but I will make my best to translate. And they see the US as the America that worked, the America that really worked. And he basically says, we should
follow America's example. They don't have labor courts, it's everything, the ordinary courts. Let's make the relationship between employers and employees much more simple, and they should agree on everything. And I've been auditing Professor KLARE's classes, and I learned a lot of stuff about American labor and employment law and about the history of the American labor movement, and some cases like Washington Aluminum, Republic Aviation, Muscoda, and even in some cases I even remember some of our principles, because in Latin America we were really strong influenced by a jurist from Uruguay called Pla Rodriguez, and we have some principles like the workers' protection, the primacy of reality, the non-waiver. But this is the way that Brazilian people like to quote American labor and employment law. And how do you feel and how do you see, and even our presidents, the current president and the former president, the Brazilian Supreme Court, how do you see this phenomenon? And as Americans that know a lot about American labor and employment law, how do you analyze that?
And just to add quickly, we have the jabuticaba myth in Brazil. It's about like this. We have jabuticaba, it's a fruit in Brazil. So they said, jabuticaba, we only have jabuticaba in Brazil. It's like here, we just have labor courts in Brazil. This is a myth. Even if we don't have just jabuticaba in Brazil, we have in Mexico, Argentina, other places. That's a big problem. Yeah, myths.
So, I don't know if you can see, I have a little picture here. So, the bottom is time, 1950 to 2020. The arrow going up is the amount of inequality, income inequality in the United States. The arrow going down is union density. And they're going in the opposite direction. Now, I'm not saying that one is the precise cause of the other. It's very complex. There's tax law, there's many, many, many things. But everybody agrees that this wonderful American system that your business people are praising has produced staggering, obscene inequality of wealth and deprivation and heartache for American people. So, I don't know what I would say if I met this man. What I can say among friends is that it's BS.
I would say amen to that. And there are many myths, including that. Well, look at the economy is doing great now as well, and that wages in the United States, even with this laissez-faire system, the wages have gone up since 1973. This is the position of the Heritage Foundation, which they took this. I was reading their findings. But again, you really look at real wages, it really is not the case. And if you look at wages, based on and tied to productivity, it goes like that. And with regard to that, and to basically to second the point of increasing inequality, linked with increased deunionization in the United States. What was one of the enabling factors, for the great eclosion, for the great crisis, economic crisis, was basically workers, middle class in the United States, not having their income accompanying productivity. And so the only way they could leverage their acquisition power was through real estate, through their property. And we know what happened. We know what happened after that. So this, I guess the point of all that is that this not only has really, really frightening consequences for a single economy, but for a global economy. So I come back to my original point. Perhaps we should have, renamed the topic of our panel tonight. The labor reforms and the American nightmare.
So I think we are out of time. We would like to thank you a lot for coming and thank Dr. GACEK and Professor KLARE. And I would like to thank my friend TALITA and the David Rockefeller Center, the HKS Brazil Caucus. I forgot to mention that Mr. GACEK is super fluent in Portuguese, and he has a carioca accent. He must support Flamengo, the best soccer team in Brazil. And have a good night.
Thank you very much.